All right, let's go ahead and get started. And it's been so long. What we're going to do is have an abbreviated startup because we already spent that time this morning. Take any questions you've got because we are standing at the crux of the next major gear shift from terms to defenses. That's largely what we're going to do in this class period. And so all I'm going to do is briefly recap what we've been doing. What we've been doing is looking at modification. And it turns out that the rules for modification have the same ups and downs and the insights as the rules for formation because you're functionally forming a new contract. And so you can raise questions around consideration for the modification, but see Lakeland versus Columber, but see cases like Shoney's, but see cases like Mama Rizzo's, which have really liberalized the ability to make a change, or Angel versus Murray, which have really liberalized the ability to make a change where there's a needed flexibility in the contract. And that very much departs from the old school common law rule, which said you had to have independent consideration to support the change in the contract, which older courts used under the Lingenfelder rule to constrain holdups. We maybe are going to constrain holdups for using some other techniques as we go through. That's pretty much it. The only interesting thing to note about cases like Mama Rizzo's was that it's essentially a statute of frauds problem, and in these long-term industrial supply contracts, you should expect the number of units to go up and down. That's our requirements and supply contracts. And you should expect the prices to go up and down. That's our pegging cases, right, where we peg it to a given index in the industry, or our set a free, you have the option to set a fair market price, 2306, and that's constrained by discretion. What I want you to see is you should expect all that flexibility. There is one common constraint though, and that's what you see in Mama Rizzo's, which is, generally speaking, for two reasons, you need a writing to modify these contracts. Reason one is because a modification requires the same statute of frauds writing as a formed contract originally does. And so if the original contract requires 2201 statute of frauds, well then the modified contract also requires 2201 statute of frauds. And the second one, as we saw in the case, is that there are also, in most of these contracts, express statute of frauds questions saying, essentially, we agree that we will only modify the contract in writing. And that's 2201C3, et cetera. And then the reason that we get, sorry, that is a separate exception. And there's two reasons that we get an exception to the statute of frauds requirement. Right, either 2201, a statutory statute of frauds, or a express written term of the agreement, which creates a private statute of frauds between the parties. Either one, they needed a writing to modify this contract. The court was mad about the double bookkeeping, and so it then went looking for exceptions, and it didn't have to look far. It found two of them. It found Restatement 139, which is our B.W. Glass case, which we've talked about before, and why using promissory estoppel to replace the requirement of a writing, it's an argument, you can make it, you may win in many jurisdictions, I'll judge you for it, but you still, as a good lawyer, you need that tool in your toolbox. And then the much easier one, which is 2201C3 as an express exception, where they've been shipping basil leaves back and forth and paying for them and doing the new change to it, we're going to say something like there's been partial performance. The goods have been accepted or the goods have been paid for, and in this case, both. And so the court's going to largely just do away with this statute of frauds requirement for modification. So that's what I need you to know. The major barrier to modification is straight up, often the requirement that modifications be in writing. There are ways around it. We've talked about two of them in Mama Rizzo's. I'm going to give you the third one, which is going to hurt your brain a little bit, but it'll make you a better lawyer. Which is, remember that even the parole evidence rule has a further massive gap that we haven't talked about much. And that is, parole evidence is always admissible to the court to determine whether the parole evidence rule applies. Now, what's that mean? It means as a matter of law, and I need you to see it. Let's say that Mama Rizzo's and their farm counterparty, they have this basil leaf contract. Now, they need to change that basil leaf contract. Let us further say that it says in the contract, we cannot modify this contract without a writing. You're in the airport and you're negotiating a proportion of this, and you're calling the other side on the phone because you're their attorney, and you're calling the other side saying, hey, can we adjust the price of this? Because like you guys forgot to put in the price for the destemming. We didn't mention destemming. That sucks. We need to destem. We need you to destem. Their response is, sure, we need like a different price, right? Cool, let's agree on this price. Cool, cool, cool. But I need you to understand the following thing. What happens if the following thing gets added? Now, this is not part of the case, but this is just getting added so that you can understand the complexity of this system. What happens if the next words out of my mouth are, hey, I noticed that this contract has a no oral modifications clause. It's got a all modifications must be in writing clause. Do you agree with me right now? You and I are now agreeing to take that clause out of the contract. And the other party's like, yeah, absolutely, we need to take that clause out of the contract because we can't get a writing back and forth right now. And so does that work? That's the problem. It works. Remember, the parties agreed, and whatever the parties agree, that sets the contract. Now, that doesn't solve what some of you were shaking your head. No. And you're right. You're also right. What does it do to the clause in the contract saying there will be no oral modifications? You must make all modifications in writing. What will our oral agreement to remove the no oral modifications clause do? Well, it doesn't breach it. It
modifies the contract.
It modifies the contract too?
Is this like where contradicts comes in?
Maybe. Although, remember, is this going to run afoul of the parole evidence rule? It's not, Lucas. Why? Because it's after. Exactly, right? This is precisely what these rules are intended for. So what does it do? Like, I know this is so contradictory. This drives people so nuts. What does this do then if we have a no oral modification clause and then we orally agree we are removing the no oral modification clause? Liam?
Just redefine that term.
Yeah, it's gone now. Like, we did the thing. We agreed to remove it. And there's no reason why we can't orally agree to change our no oral new agreements clause. So for the private statute of frauds, the ones that appear in the contract, the clause that says no oral modifications, that clause can be orally taken back out. But what doesn't that do to say, oh, we agree to take that, we agree to change that clause? What doesn't it do? It does take that contract clause out, right? We see that? What doesn't it do if I say on the phone, hey, I notice this has a no oral modifications clause. We need to modify it. We're going to take it out.
Do you run into an enforceability issue?
We do because of what? What statute? Because of the parole evidence rule, and particularly the statute of frauds 2201. That's a statutory statute of frauds. That's saying that there is a bar to enforcing this contract unless you have a writing that meets the standards. And so there's at least an argument that this oral evidence paradox, which is that oral evidence is always introducible, to see if oral evidence should even be excluded. And so you can always get it in, and once you do, you can make claims like, hey, we orally agreed to remove our own contractual statute of frauds. But it's a much harder argument to say, we also agreed to bypass 2201, the statutory statute of frauds.
So is that only while it's executory, though? Because if they start performing on that contract that's now modified with no oral modification clause removed, is it then enforceable?
Well, yeah, that's exactly what they did in Mama Rizzo's, right? They said, you didn't get it in writing, and then the court made up two reasons why you didn't need a writing. Reason one, Restatement 139, which is our sort of Section 90 mutated in the direction of we're no longer replacing consideration with reliance, we're replacing the need for a writing with reliance. So that's one. In BW Glass, they added Restatement 139 as an exception to 2201, even though 2201 does not have an exception for reliance, right? But then the other one they did was they said you performed it, and therefore the part performance exception to the statute of frauds means that you no longer need that writing. That's exactly how Mama Rizzo's comes out that way. It's a great question. Yeah, Bailey.
It feels very much like a lever situation.
Absolutely.
Is it more like how well you argue, or is it kind of like the court is kind of look at it and see kind of who's the jerk in that situation?
Yeah, my particular rule is you want to give the court a reason, and I thought like your analysis of Mama Rizzo's was really great because it stood right up against Shoney's, right? You identified that it's the same fact pattern as Shoney's, but I thought that it was really interesting to see the lever because Shoney's and Mama Rizzo's both come to the same conclusion. Double bookkeepers suck. And if you've got a long-term supply contract, whether it's for chicken or for basil leaves, and something happens to the circumstances that you didn't anticipate, and so you need to modify that agreement to keep it working, and both sides agree to that, you better believe courts are going to hold parties to those changed terms. They're not going to go for this double bookkeeping. What's interesting, though, is that the court does it in completely different, using an opposite, they get to the same result using an opposite framework each time, right? So in Mama Rizzo's, they say, oh yeah, this is a long-term supply contract. To modify it, we need a statute of frauds writing, but we don't need that because of Restatement 139 and because of Section 2201c3. Those two exceptions mean we don't need that writing. The way it worked was to get that modification past the statute of frauds rule. That's not at all what they did in Shoney's. Right? In Shoney's, what they did was they broke the contract up into smaller contracts, each one of which represented a firm offer to buy at a given price. And what that did was that let the party who needed to adjust the price raise or lower the price because it was a new contract every time. So one party gets away with the same result, and it's the same reason the court's pissed, and they're diametrically opposite yanks of that lever, right? One of them's pulling the lever all the way down to, let's split this deal up into monthly separate contracts. And the other one's like, nope, this is all one huge contract, which we are modifying after we made it. We're modifying after we made it, so parole evidence doesn't apply, and we need a statute of frauds writing, except we don't. Section 139, Restatement Section 139, and 2201c3. So what's amazing is same case, same facts, same goal, completely opposite legal theory. The court, the attorneys in both cases really made good use of the lever to keep the ship going where they wanted it to go. And even though both sides, all of them wanted to get to the same place, they used exact opposite pulls of the lever. Yeah.
So you would say like that the economic public policy argument that both courts made, and they found law to make that work. Do you think that's like a good example of where policy and law kind of actually dovetail together?
Absolutely. I mean, I think courts are using doctrine to constrain opportunistic behavior by the litigants. And it's just what the opportunistic behavior is. They'll explain to you why the common law stops that, but it's a bit more of a circular process than you might think, right? So opportunistic behavior in Lingenfelder, we're going to stop that by dropping the hammer on the doctrine of consideration. But opportunistic behavior under these, long-term, like under the Shell Oil cases, we're going to constrain that by saying, oh no, you posted a listed fair price. The fact that you were engaging in shenanigans doesn't matter. You listed a fair price. In each case, despite the fact that they're using completely different doctrines, and both in Shoney's and in Mama Rizzo's, again, they're stopping opportunistic behavior, which is the contract needed to be modified. They screwed up the original contract. It's not even screwed up. Long-term supply contracts, they just gotta change. And so we knew that, and they changed it, and the parties negotiated that in good faith, and then one party's trying to roll that deal back secretly after the fact. That's the opportunistic behavior the court's constraining. What's interesting between Shoney's and Mama Rizzo's is to watch that lever, how the court uses either end of the lever to constrain the opportunistic behavior that they're trying to drop the hammer on.
And so if they're both really perfectly good levers.
Yep.
Good law, right?
You got it. And that is how this whole class works. And all of law school, by the way, as long as I don't get into too much trouble with my colleagues, but that's how all law works. Yeah.
And so just to sum, even though there's a lever you can pull, won't necessarily impact the outcome. Defense might win on either side.
You can, that's the point. That's what I'm trying to tell you is we are in this class not to learn how to win cases that you are reading that someone has already won. We are here to learn how to win the cases that it looks like they lost so that you can win more than 50% of your cases, which I profoundly hope for all of you.
Thank you.
I thought the court was doing some gymnastics with the no waiver clause in this case.
Oh, really? They really were.
Yeah.
Like mental gymnastics, like just
Right.
backflips.
Yeah, it was a little silly. But do those no waiver clauses sometimes have traction? I mean, obviously. in
Yeah,
this case,
oh,
they were-
overwhelmingly they do.
Yeah.
Overwhelmingly they do, because if I teach you one thing, it's courts love to enforce contracts as written.
Yeah.
Boy, do they love nothing more than enforcing a contract exactly as written.
Yeah.
And to get into these no waiver clauses, we would have to play games like, but you and I agreed orally to modify the no waiver clause, et cetera, et cetera. Like you would need some theory that gets you past that no waiver provision.
Right.
And the big way to get past the no waiver provision is exactly what you pointed out, giving the court wind beneath its wings so that it wants to do bat flips for you.
Right. Yeah.
Yep, that's exactly it. Okay, cool. Let's move on. We've got one case cleaning up here, and then we're going to move to defenses. And so the next case is, again, about modification or a specific kind of modification, but it's almost back to the dissent in Lakeland versus Columber. It's almost back to the Lingenfelder rule. And in fact, it's almost back to our maple syrup farm case, which we'll talk about a little bit. And these are the rules on substitute performance and accord and satisfaction. So this is the case of Wong versus Peisner. This is one of these old school cases that is on every bar exam. It is one of the very few cases that is there to straight up tell you what the black letter law is. So Valeria, would you mind setting up Wong versus Peisner for me, please?
Sure. So here we have a plaintiff who agreed to contract with the defendant for these mechanical drawings he was going to make.
Yep.
And so they agreed on a lump sum payment of $1,000. And then the plaintiff claims that there's a modification to an hourly rate, which means he would get like $5,400 versus the defendant says, we didn't do that, we didn't agree on that, we agreed on a $500 additional lump sum, which he paid. So he delivers the mechanical drawings, and then the defendant sends in a check, and it says like payment in full for $1,000. He says he threw in like an extra $500 to appease the plaintiff because they had like this misunderstanding. So the defendant, he deletes the payment in full part of the check and he deposits it. And then the textbook on note 3 says something about it being like a liquidated debt. I'm not sure what that means, but I think it's important.
Yeah.
So the plaintiff sues, and then the jury finds the plaintiff, and then the defendant appeals and argues that the judge made a reversible error because he didn't instruct them on accord and satisfaction. And the court looks at Restatement 278 and 281. 278 says if an obligee accepts in satisfaction the obligator's duty if performance offered by the obligor that differs from what is due, the duty is discharged. So in this case, the plaintiff got this check for $100, accepted it, and they said that the additional like $500 could be construed as consideration to accept the $1,000 to be like the full payment. It doesn't really matter, like there's no legal effect of him erasing the payment in full. So the duty would still be discharged despite the fact that they don't agree on what performance was, because that $500 was the consideration.
Got it. Okay. That's exactly right. Let's just bear down on it. We're talking about another kind of modification of a contract. And this is the ones that we've been looking at so far are modifications of a contract that occur while the parties are trying to make the contract work. Accord and satisfaction and substitute performance are modifications to the contract that are made after the parties have, if not started litigation, have begun to threaten it, have entered into it saying, you're in breach now. And I want you to see the theory. The theory is, look, let me ask you this, Valeria, why would we want to hold people to, as a practice tip, if someone sends you a check for your legal services that says $1,000 payment in full and they owe you $30,000, do you deposit the check? Okay, now we know what to do with all of this. Now we know what to do with all of this. But let's get to the bottom of it. Why would we want to enforce deals like that? Like, you're not going to accept it, but why would, if somebody did accept it by depositing the check, why would we want to say, yeah, there's every reason to apply the law of accord and satisfaction, which is y'all agreed, to change the requirements under the contract to this? Why would we want to do that? So as a black letter law move, first of all, realize how this reaches all the way back to consideration, right? By the way, could you say with a straight face that it wasn't at all supported by consideration? How?
Because it was like a pre-existing duty, it was already part of the contract. So
Bingo.
why would we renegotiate and get less money?
Yeah, absolutely, right? Because this was already part of the contract. We can trot out we can say this is fully supported by consideration, because or we can say, no, pre-existing duty rule. You had the obligation to pay me $5,400. The fact that you paid me $1,000 does not mean you do not have the obligation to pay me another $4,400. That is the textbook application of the pre-existing duty rule, right? So we can, even when we do consideration, I want you to see what we're doing. All we're doing is we're pulling a tool out of a hat, and then we're saying, watch this, lever, 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 like whichever way we want to make consideration go. As a practical matter, what's going on here and why are courts going to start saying things like, we are going to enforce this change without consideration, which is what accord and satisfaction is. Austin?
To resolve disputes like this out of court.
To resolve these disputes, to preserve our ability to settle cases. Nate, you were going to say.
Yeah, and I would add that also to give parties to contracts flexibility to, not miss other opportunities because they're stuck waiting for someone to pay them in full. They want to get half and move on.
So that begins, so I think it's Austin's insight that gives us the framework then to understand some real rules that give us traction in cases like Wong versus Peisner. Valeria, what do you think drives the difference here between this? There is consideration here. First of all, which way do you think this goes? There is consideration for the settling of the lawsuit. Do you see what it is? It's consideration for settling of the lawsuit. I will offer you more in settlement if you will settle your damn claim. And that we do all day long. And then the other side says, but you are already obligated to do this. The fact that you did part of it means I get to charge you the full rest of it. And we generally, by the way, don't let people do that, because why? Why don't we let people come to accord and satisfaction and then go back on it?
Is that like the architect case, like you would just extort them for more money?
So it's an extortion technique?
Then there wouldn't really be any viable contracts if everyone was.
Yeah, then there wouldn't be any viable contracts at all, because people would always make this pre-existing duty rule, and you wouldn't be able to modify them, because usually what happens is something happens that somebody didn't expect happens and prices go up, and so you need to adjust the price. That's almost always what's going on. And if you say you can't modify contracts under that standard, these longer term contracts and cases don't settle. And so we're absolutely going to try to bear down on this context of settlement. All right. In light of Austin's answer, let's just say here's the, let me give you a shot. Larry, what would you do to divide between the two? To say, some of these are holdups, some of these look like legitimate attempts to settle a real dispute. What would you be looking at to say, I'm real comfortable being on this side of it versus I'm more comfortable being on that side of it? What would divide things? Yeah, sure, Liam.
Good faith.
Or something like it, yeah. I mean, what's it look like? By the way, that turns out to be the technical term. It's just that it's different kind of good faith in a completely different area. It's no longer good faith in the performance and execution of the contract. This is more good faith. What are we testing as a matter of good faith? Because see, look, the pre-existing duty rule hits. Let's say I sue you because you are in fact a lizard person. That's why I'm suing you. And you're not. And then I agree to settle my lawsuit against you for being a lizard person, and you agree to settle it, can you see how there's at least an argument that like you had no serious legal claim at all? That you're not giving up anything? But how is that different from, I'm suing you, you agree to paint my house and you go way over. And I'm suing you for the difference between the extra amount that you're charging me. I think that that needs to come down. And you think you actually ran into some problems, which is my house is 3 stories tall and you needed to do extra ladder work and have extra insurance and stuff. And so you think it needs to be even more than that. And we're having this fight back and forth about it. What's good faith about that?
I was going to say objective versus subjective, but no. But I mean, good faith is like, I guess, like, you can't really tell with good faith from the original argument. Like, was a person, like, do you know if they're lying or not? And it's another one, like, it's measurable.
Yeah, go ahead, Nate. Oh, no.
I had a thought of that.
Yeah.
I was going to say that it's, sorry, sorry, Gene, go ahead.
Go for it.
I really like Ben's entry of that, something that's measurable. I would just say it's like, so long as there is an arguable basis.
There it is. Right. That's where good faith lands here. It's saying, look, as long as the claim was in good faith and wasn't just a complete joke, then courts will say, we're not measuring who was right or wronger. Y'all agreed to settle your lawsuit. We're done now. It's only in these absurd extreme cases where we know that one party is just simply, like they have no basis to assert what they're asserting, where we will trot out that old Lingenfelder rule and say, nah. All right, this is based on the restatement. The restatement has 2 ways of doing this. The one is there's been a breach of contract and the parties are settling the lawsuit. And that is going to be, we're talking here about restatement 278, 279, and then accord and satisfaction, which is 281. So 281 says the parties had a lawsuit, and as long as each party had reasonable grounds or even any good faith grounds, like it's a pretty low standard because there is nothing as scathing as attorneys talking about the validity of opposing counsel's arguments, right? Like you're always going to be describing their arguments as just complete bullshit and nonsense and a waste of everybody's time. I think we all understand what you're really doing in that context. Don't get high on your own supply. Don't believe what you're saying, but I think we all understand what's going on there. And so that can't be the basis, right? Just saying that each attorney is really unhappy with the strength of opposing counsel's arguments can't be the basis for undoing all legal settlements. So that's what 281 says. It says, look, as long as there's a good faith basis to assert the claim, the fact that you gave up the claim is consideration for other people's offerings to settle the claim. And once that's happened, it has settled. It is going to settle out of court. To protect our ability to settle out of court, we will protect accord and satisfaction. Substitution is more or less the same thing. It's saying, yeah, there was a breach, but the parties have agreed to substitute the performance under the contract. They're modifying the contract for new substituted performance. So it might be something like this. I agree to sell you a car. You have learned this is not a wise move, but you still agree to buy a car. That car is my truck. It doesn't go anywhere. You sue. I say crap. Fine, I'll offer you the Ford C-Max in substitution. You say, sure, and we shake on it. You can see how that also meets our modification standard and why courts would allow for substituted performance, as long as the parties seem to agree to it. Again, subject to the, is this a holdup? If it's a holdup, courts are not going to go for it, and they may trot out old doctrines like consideration or whatever they're going to do to stop the holdup. But as long as they sense that there's a reasonable attempt by both parties to resolve a dispute, they're just going to let the parties resolve the dispute. Full stop. All right. Any questions on Wong versus Peisner? Sweet. Oh, Kavler, yeah, go for it.
Yeah.
You get to ask.
Could you explain the thing with the liquidated debt versus unliquidated?
Sure, absolutely. Thank you for raising that. That's actually the most important part. It's just, we haven't gotten to damages yet. So look, damages, as you might imagine from this class, are going to be a bit of a disaster in contract law. And that's because the basic measure of damages, we will have many more other measures, but the basic measure of damages is we want to put the non-breaching party in the position she would have been in had the other party actually performed the contract. That's our basic expectation measure of damages. But the problem is that world doesn't exist. They didn't perform the contract, which means we are in a different world where the contract wasn't performed, and unbreaking that egg turns out to be a complete disaster. So there's only one thing courts love even more than clear, unambiguous contract language that they can rely on to dispose of a case. There's only one thing they love more than that, which is the parties have said, if there's a breach of this contract, the damages are this. And they just say it in the contract. That's what liquidated damages are. Liquidated damages are your deposit, your safety deposit. That's a kind of liquidated damages. Your earnest money that the other party can keep if you don't follow through. Those are liquidated damages. They're damages that the parties have agreed on as part of the contract are the damages in the event. And you can imagine how much leeway courts give parties to set those things. They love the parties setting the damages amount more than anything because damages are money, money is value, and value is inherently caught in this subjective-objective disaster that the courts can't even begin to get into. They don't know what it was actually worth to one party, other than the cash on the barrelhead they offered for it, or the damages that they wrote in the contract. And so if our contract says, you have given me $1,000 of earnest money, and I get to keep it in the event you don't follow through with the contract, and the parties agree that these are fair damages for our breach, that's liquidated damages. Can you see that when that happens, if they say, I am offering you $500 as accord and satisfaction, the court's going to Lingenfelder the hell out of that stuff. Be like, no, there wasn't actually a good faith dispute here. Y'all decided in the contract what the damages were. There wasn't a dispute. You're making up a dispute in order to get the price down. And they're going to say, nope, where the damages are liquidated, you don't get to come along and just offer to pay half of what you already agreed you owe. Great question. Thanks so much for following up on that. That's awesome. We will see liquidated damages again when we get to remedies at the end of the class. For now, it's just an asterisk. All right. Any other questions about Wong before we switch? Yeah.
Is this like why, when you hear on the radio like the tax relief, things are going to be fix your taxes, it's going to say then, like, look, my client can't pay, we're going to bring this claim, and it's better for the IRS just to say, like, fine.
Yes, although many of those outfits are predatory. But other than that, yes, that is the kind of negotiation they're intending to do because they're not, look, at some point somebody's under financial stress. They're not going to be paying the amount that they owe. And so just to negotiate a lesser amount that they pay in order to solve their dispute is great for both parties. And that's why courts will enforce it. Okay, cool. That's our last one on modification. We are now going to enter defenses. We're done with contract terms. We are now entering defenses. I don't have a lot to say about defenses other than this. Keep very much in mind what asserting a defense means. It means, question 1, there's a contract. Question 2, that contract is enforceable. Question 3, the terms of that contract establish actionable promises between the parties. Question 4, they breached those, and here's where we are. Even though they breached those, there is an argument that for some reason, we'll have a few different reasons, most of which won't matter all that much. I hate to say it, the stuff that we're doing today doesn't matter as much as you think it does. We tend to do this through the restatement 200s through 220s. We tend to not, we do this Colfax ways. We don't do this the way that section 151, 152, 153, and 154 really talk about. We'll go through the arguments, it's fine. We're gonna get to the big defenses though. Illegality starts to get there. Public policy starts to get there for non-compete agreements. But the real one that the rubber hits the road is the defense of unconscionability. That's the 800-pound gorilla in this area of law. So that's what we're going to do. Any questions about defenses more broadly? The main thing you need to see is what the argument is, that we're now saying there's a contract, it's enforceable, we know its terms, we know you breached them. We're now saying, fine, is there some reason why you still shouldn't have to pay, even though the foregoing 3 statements are true? Is there a reason why you still didn't breach? Is there a defense? Yeah.
Just clarifying number 5. There's a contract, enforceable, it establishes promises, the party breached them, and for some reason.
Right. And I'm trying to line them up roughly with our categories in the class. So I get it that my 4 and 5 have gotten a little messy, but let's stick with it. There is a contract, that's question 1, contract formation. It is enforceable, that is contract, that is question 2, formalization. We know what its terms are, that's question 3. We know both its express and its implied terms. And then what we're saying is one party breached those, that's what we're like at 3.5. And then we're at 4 now. Is there a defense, even though there's a contract and it's enforceable, we know what its terms are, and you breached, can you get out of it?
Sorry, yeah, I thought you meant there were 5 things within defenses. I didn't realize.
No. We're just trying to tie it to the overall structure of the class. Okay. Any other questions on that before we start piling into some of these things? All right. We're going to do misrepresentation and what's called mutual mistake and unilateral mistake first. I gotta say, we have seen these cases twice before, and the most important thing I need you to see is where in this class you've seen each of these arguments before, because it's the 3rd time we're gonna see the same argument, just at a different argumentative point in the class. Here we're doing it as a matter of defenses. But let's start with misrepresentation. Chris, if you wouldn't mind, with Weintraub versus Krobach.
Yeah. So Weintraub owns a 6-year-old townhome. She gives it to a broker, starts selling and advertising and stuff like that. The Krobaches are interested. They tour it while it's illuminated and find it suitable. Then they proceed with a purchasing agreement on June 30th. They agree to sell the property for $42,000 and $500. The contract provided that the purchasers had inspected the property and were fully satisfied with its physical condition, that no representations had been made, and that no responsibility was assumed by the seller as to the present or future condition of the premises. So there's a lot of reinforcement from a certain pattern of argument that will come up. After signing the contract, the purchasers discovered a severe cockroach infestation and a non-illuminated inspection. The purchasers, so Krobaches, try to get out of it, and then their lawyer had the argument that the presence of vermin in like such great quantities, like they literally described it as they like entered a room and every single direction, like a horror movie, cockroaches were going every single direction. The presence of such so many bugs made the house unfit for human habitation, and therefore they tried to rescind the contract. The homeowner, Weintraub, denied this. She denied knowing anything about this cockroach infestation, which I don't believe. And then the poor broker is like kind of in the middle of this and just wants the commission. But the main issue here, and it got kicked up to the Supreme Court of New Jersey. The main issue here is, does the seller owe an obligation to let her know of this infestation? And then later, the homeowner argues that even if she did know about the infestation, she wouldn't have any duty to tell her, and they cite some really outdated case law in Swinton, and the court goes through and basically rejects Swinton. They adopt the Schleiermacher standard and basically determine that they should get kicked back to a trial because there is enough facts in the complaint that this could be determined by a jury. Was there a duty to inform the buyer?
Was there a duty to inform the buyer? Okay, y'all, like I really struggle with how to teach this case because there's a lot here. I'm gonna start with just then, let's get the black letter law nailed down because we are about to do violence to this case. All right, so let's get the black letter law nailed down. What's the black letter holding of this case, Chris?
Well, this is a common law issue.
Yeah, I was gonna say, what law are we under? Absolutely. Why? I thought cockroaches were movable. It's a house, it's real estate, it's under the common law. Great. Which really matters, by the way, because a lot of that language that you were talking about that really bolsters that stuff up, like we make no representations, and what's that sound like?
reminded me of like a warranty thing. Like,
Yeah, what part of warranty is that whole, like, I've made no representations,
as is and stuff like
as is with all faults. Look, to be clear, this house was sold as is, and when I kick the chair out from under this case and start doing violence to it, that's going to be where I start, right? But let's back up. We're under the common law, and although the court doesn't cite it, we're under common law restatement 164. And what's the holding that the court says might be possible? I understand they kick it back down, but what might be possible in this case since the court is protecting it?
I mean, it could be possible that there's just a summary judgment, because well, actually no, that would be up to a jury to.
Yeah, it's what's up to the jury to decide, right? They kick it down, but what's the jury supposed to decide when they do kick it back down?
The jury's supposed to decide if whether the seller like deliberately concealed it.
There it is. That is whether the seller deliberately misrepresented. So this case is misrepresentation. It is a defense. First of all, in this case, was there a contract? Was it enforceable? Do we know what its terms are? All right. We're on defenses. What's the defense? I'm being pedantic, but what's the defense, Chris?
We had no idea of the infestation, or even if we did, we have no duty to let you know of it.
So on the other hand, we have no duty to tell you about that. So the idea is the defense is 164. You misrepresented stuff, and so you secured my agreement to the contract by lying. And if I'm going to give you some black letter law, I would say for a case like Weintraub, active misrepresentation is a sign on the bar that they want you to drop the hammer and use misrepresentation. But also, was this active misrepresentation, Chris? Did they straight up say there are no cockroaches?
No, it's like omission. It's like
Yeah, by concealment. And so, although the case goes further and starts talking about you need to reveal things that the other party doesn't know, and you know that they don't know these material facts, and you know that those material facts are important to them, the court does go further than where we are right now, but we are about to start doing violence to the case, and I'm about to demonstrate to you that what the court says there is bullshit. So let me give it to you. Weintraub stands for the proposition that in residential real estate transactions, active fraudulent misrepresentation or active concealment of misdirecting someone away from finding the thing out constitute grounds for voiding the contract. That is the black letter law as close as I can give it to you in real life. The most important thing that I had to say about that is in the first part of the sentence. Notice that I said I cabined this case to residential real estate. This is not a principle of broad application. This is residential real estate. And we're going to talk about why. But first I'm going to talk about why when the court goes further and says, this is what it actually says the rule is. This is not the rule. So I'm not asking Chris what the rule is because the rule that it says is not the rule. What it says is if one party is aware that the other party doesn't know something and it is materially important to that party, then the first party has this obligation to disclose it. And we need to go to the depths of why that statement is so profoundly dangerous as a matter of common law. Okay. When I went to buy a house, I learned that some genius had written up Lexington, and this would have been sort of 2007. Some genius had written up Lexington in one of these top 10 places in the country to retire lists that people took very seriously. And so in 2007, this is what we're talking where, when dollars still existed and were worth anything. In 2007, most of the homes there along Main Street were over $1 million. Now that is not what they pay me at all. Like there's no earthly way I could have afforded that. And I did have 4 kids. So I needed a place where we could go. And I worked it out that as long as I drove outside of town, every mile I drove outside of town knocked about $10,000 off the asking price of a house. And so I just drove until I could afford something. But when I did find something eventually, and there were some real moments of vindication, like there was one house we put an offer on. This was right at the explosion, the 2008 meltdown, complete financial meltdown. And like I got calls back, like we had made an offer. They said, no, absolutely not. And then I was like, okay, cool, we'll go somewhere else. And then like a year later, they're like, we've been carrying this house for a year. Would you consider the offer you originally made? And I was like, no, we bought somewhere else. So those are moments of vindication. But when I did in fact buy the place, we got caught a bit by surprise. We found a lovely house and we made an offer on it. And it turns out they accepted it for reasons that we didn't understand at the time. We didn't know why they did that. Here's the thing. Let's say I lowball that house. You don't know anything else about my house, but you know one thing. Is there a fact involved in that transaction that the other side very much wants to know, that they don't know, that I know they don't know, that would be incredibly material to their decision to sell the house, and that there is not a snowball's beeping chance in hell any court will ever require me to disclose, ever?
I was going to say your income or your wealth.
My income and my wealth is beginning to bear on it. My reservation price, how much I am willing to pay, which is definitely based on, like how much I got going on, right? My reservation price. Y'all, why would forcing parties to disclose their reservation price, that's their cash on the barrelhead price, the highest they would go, why is that something that contract law will never, ever force you to disclose?
Because the contract is a bargain for exchange, so you're taking away part of the bargain.
Because that's the whole damn point of the whole damn class, is that people value things differently, and it's that spread in value that makes bargain for exchange a source of wealth. The whole thing only works because I value the cup of coffee more than the coffee shop values it. And they value the cup of coffee less than I value it. That difference is the surplus. By the way, look at online targeted behavioral advertising. We've talked about the problem of when they learn enough about you, when you're playing economic poker with somebody who can see your cards, and so they charge you all you can pay. When Uber hits you with 10 times surge pricing because your battery is at 3% in a bad neighborhood at 3 o'clock in the morning, and which they are very well aware that they can do. They've committed, at least publicly, a couple times not to do it. I'm not sure I believe them. But anytime that perfect price, was called perfect price discrimination, that's an attempt to remove the consumer surplus. But what I need you to see is the consumer surplus comes from this differences in value. So what we know from the start is that the language of Weintraub is nonsense on stilts. And let's just try to build it out from there. Let's say I sell you my truck, and you've now taken enough of this class and you know enough about the truck. So I sell you my truck as is with all faults. And you buy it, and it turns out there's a very friendly family of mice that are living under the hood. Can you sue me for violation of the implied warranty of merchantability? Fitness for a particular purpose? If I say I am making no guarantees about the state of this truck at all, I have told you what this truck is like, I have told you at length, I make no other representations, right? Is there an argument? Can you Weintraub versus Krobach this after the fact? Can you say you knew about the rats when you had a chance to inspect it? When you had a chance to look for yourself? When I told you I was making no representations, when I told you you were buying it as is with all faults, that language allocates the risk of something that the parties don't know about to who? The buyer. That's what as is with all faults does. It allocates by contract the risk of some default to the buyer. And if the buyer doesn't like it, don't buy it as is and with all faults. Okay. You see what I've done? I've started one by saying the statement of the court in terms of when you have to disclose certain information that the other party doesn't know is obviously nonsense as written. Then we stepped back one and I showed you how in goods cases, Weintraub versus Krobach would never even happen. But let's take it one step further. Let's say you are trying to open a kombucha business. And so you come by and you look at a piece of commercially zoned property. And I say to you, yeah, so here's this parking lot / building on the way. There's a couple of them, kind of dilapidated buildings on Route 11 heading out of Lexington. You can go sort of see them. Every once in a while, it's where businesses go to die, like they just kind of crop up there every once in a while, and then they're sort of gone 3 months later, that kind of thing. There's a lot of vape shops out there, like a lot of vape shops. Okay, so let's say that I offer you that kind of space to do your kombucha, and so you go there and you're like, okay, cool, and you like have your termite inspector go check it out, and you like take a look at it, and I say, look, I'm making no reservations, like I'm making no representations about what this property is like. I'm using all the language we used in Weintraub versus Krobach, right? Saying I'm not making any representations. You're going to take this property as is with all faults, and I sell it to you. Do you think they get to Weintraub versus Krobach me afterwards? They really don't. Why not? Yeah, like you had every chance to inspect it. It's commercial real estate, right? What rule do we, by the way, use for that general idea that when one party disclaims all responsibility and the other party buys it, it's kind of their problem? A little bit of Latin gets involved.
It's
Caveat emptor, which, by the way, is not an ancient legal tradition. It's just a couple hundred years old. They're just making this crap up. Like, they're just like, what, caveat emptor? That's actually not historically true, but boy, does it have a lot of base level ring to it. And so what I need you to understand is that Weintraub versus Krobach is not a general example of if you know something the other party doesn't know, and you know it's important to them, and you know it would change the outcome of the decision if they knew it, you are absolutely not required to tell them that. Defense in this case is right, just not with residential real estate. Why?
You want people to buy homes.
You want people to buy homes, right?
And you don't want them to buy cockroach-infested homes.
You don't want them to buy cockroach-infested homes, which we will begin to see. There are a number of other implied terms under public policy that say things like, you need to manage your rat problem if you're a landlord, right? Scott.
I think just the nature of the party, like they're people and not businesses, so they're not very sophisticated.
So people aren't businesses. They're doing this in their personal capacity, not in their industrial capacity.
Because there's so much that you have to check out for a home.
There it
any
is.
Individual piece of extra thing you would have to purchase as a home buyer would be a barrier to making that home transaction.
I mean, I think that's probably it, right? Just the costs of finding certain things out are so much higher for residential home buyers than they are for sellers or renters. The renter knows so much more about it. This is one of our cheapest cost avoiders. Remember that from Colfax? This is one of our cheapest cost avoiders cases. I don't know. I may get out of this class, go upstairs and write down, hey, that'd be a great policy question. Give me every case and comment and point in the class that constitutes cheapest cost avoiders. That's exactly the kind of question that I'll ask when I do a policy question. And this is clearly one of them. Cheapest cost avoider. You can see how the court might drop the hammer in the case of residential real estate, because it's very much not like, where we're talking about commercial property, well, I don't know if there's a problem with the property. Neither do you, and I'm in no better position to know than you are. I've just been holding this land as an investment, and I'm happy to sell it to you. I don't know anything about it. Whereas in residential real estate, especially because builders build residential real estate, and sometimes there's really flaws in there that they know about that nobody else could possibly know about. And because it's so hard for residential home buyers to buy it, and because freaking cockroaches, and as we will see later, rats, really trigger courts. Because of those things, we get the Weintraub versus Krobach rule. But I need you to understand its limits. Any questions on Restatement 164 and the limits on it, like Restatement 87, which sounds like it's for everybody, but is actually just for construction cases, AA builders. So Weintraub versus Krobach, Restatement 164. Sounds like it's for everybody. It's freaking not. It's freaking not. You do not have to disclose. Look, and here's another way of putting it. Let's say the reason that I bought that house, to finally end my story, the reason I bought that house, let's say, is because I had done a survey and I'd found that there was actually oil or gold under the house. Do I have to disclose that to the seller? Of freaking course not. And why would I not have to reveal the fact why I want the property? Why do I not have to reveal why I want the property?
Should they already be aware and they've taken the risk that they might be selling
Yeah, that's what a sale is. It's an allocation of risks of the unknown. The seller's risking that it's not worth more than they're selling it for, and the buyer's risking that it's not worth less than they're buying it for. Like, I mean, come on, y'all. That's what price points are for. And so I'll finally just end this by saying, y'all, like the reason that a court would never apply Weintraub versus Krobach in a million years to a truck is they'd say, yeah, well, looks to me like the price you got for the truck, and I'm about ready to sell it for the cost of getting it off my property at this point. The price that you got for the truck is an agreement on the allocation of risks of unknown stuff. Price serves as a risk allocation. For both parties, the price is a bet. All right? Cool. And we don't save parties who make bad bets. Like, that's the basic rule of the whole course. We don't save parties who make bad bets. All right. Any questions on that one before we get into unilateral and bilateral mistake? Cool. Moving on. Oh, I will notice we talked about Asmus versus Pacific Bell and that employment program when we talked about Lakeland versus Columber way back in the day. You might want to reread that at 433 to take a look to tie that to our Lakeland versus Columber. Go reread Lakeland versus Columber and then read the stuff on Asmus versus Pacific Bell on 433 and have kind of an aneurysm about it, because I do. But other than that, we're going to let it go. Okay, that's Weintraub. We're going to move then into Lenawi County Board versus Messerly. All right. Nick, if you wouldn't mind setting up Lenawi for me, please.
So Carl and Nancy Pickles purchased William and Martha Messerly a 600 square foot tract of land with a 3-unit apartment building on it. Shortly after the transaction was closed, the Lenawee County Board of Health condemned the property because of the septic tank issue, making the apartment uninhabitable.
Right.
Uninhabitable. The Pickles wanted to rescind the contract because the whole reason they bought it was for an income property, and they said that it was a mutual mistake because the Messerlys also did not know that this was an issue, but maybe they did. In the contract, it said purchaser has examined this property and agrees to accept same in its present condition. There are no other or additional written or oral understandings. The Pickles didn't realize the septic issue until they went to meet the tenants. And the court looks at the previous owners, which was Mr. Bloom, who had installed the septic tank. And after the Messerlys had owned it, they sold it to the Barnes. Barnes sold it back, and sold it to the Pickles. So the court said it looks like there might be a mutual mistake. And then when considering the rescission, they looked at, if they're both innocent, what party should bear this burden. And they placed it on the Pickles.
Well done. Why?
Because they assigned the risk of loss through signing it and not inspecting it.
Through signing it and not finding it, they accepted through the terms. What terms assigned the risk of loss to the buyers?
It was where they said that they were buying it like as is.
As is, with all faults, all that other similar language. Identical language, by the way, that we just, it's also residential property. Was a residential property. This is the same case, right? And we need to figure out why the hell it's coming out very differently. Okay, let's do black letter law first, and then we're going to get funky on this. What is the law? What law are we under? We're under common law, and specifically under the common law, what restatement provision are we looking at? 154 says?
For determining when a party bears the
Okay, so the question, this is the single biggest question, 154, who bears the risk of a mistake? And it's the same thing we've been saying before. The party who agreed we bear the risk of uncertainty. And that's through the as is with all faults clause, the buyer, right? Give me another way in which the parties probably straight up assigned the risk of a sewer problem and also assigned the risk of, frankly, anything else being wrong with it, like sick building syndrome, black mold, termite, like anything else that the parties didn't find. What's another way that they did it other than with that as is and with all faults? Like if you didn't have that language as is with all faults, could you still make the argument that the parties allocated the risk of uncertainty to the buyer?
The clause provides that the purchaser has examined the property and agrees to accept same in its present condition.
Right, so there's an inspection clause, which is really powerful and really nice. And then the price, right? So there's a couple of other ways that we're doing it. We're not just saying as is with all faults, we're also saying you had the opportunity to inspect and you didn't. And also the price is going to represent an express allocation, right? The price is a bet by the buyer that it's not worth less than they're paying for it. And the price is, look, if they'd have found gold underneath the property, could the seller have rescinded the contract and gotten the property back? Absolutely not, right? Do you see it? So the price allocates the risk of stuff we don't know, and it allocates it very precisely. It allocates to the buyer the risk that it's worth less than the buyer bought it for, and it allocates to the seller the risk that it's worth more than the seller sold it for. The whole thing kind of makes my teeth itch. All right, now that's 154. Let's also take a look at 151, which is the other part of this thing. And 151 says, a mistake is a belief that is not in accord with the facts. Fine, great. Now we know what that means. And 152 then says, when mistake of both parties makes a contract voidable. This is the doctrine of, what kind of mistake are we talking about, Nick? Mutual mistake. This is the black letter law of mutual mistake. So you go to Restatement 151 for your definition of mistake, and you go to Restatement 152 to find out when the mistake of both parties makes a contract voidable. It turns out we don't even use 152 all that much because 154 is there in the back saying, well, one thing is when the parties have said in the contract who bears the risk, then we go with that. So we don't even need to ask 152. But in case we wanted to ask 152, here it is. Where a mistake of both parties that the contract was made as to a basic assumption on which the contract was made has a material effect on the agreed exchange of performances, the contract is voidable by the adversely affected party unless he bears the risk of mistake under the rule stated in 154. So you could void it due to mutual mistake. Fine. But that's not what's going on here. Now there's a couple of problems with mutual mistake as a doctrine. First of all, just as a practical matter, let's say that both parties in fact did make a mistake. Like I intended to buy a green Ford C-Max, and you intended to sell me a green Ford C-Max, and it turns out the contract gets written up for like a 2025 Hyundai like Sonata. So that's mutual mistake? With me? Right? Why don't we end up using 152 to do that a lot of the time?
Because nobody sues.
Because nobody freaking sues, because we just go and fix the mutual mistake. Like if it's a mutual mistake and the parties still want the deal to go through, then they fix it. Which means the only mutual mistake cases we have are a little bit different than that. The only mutual mistake cases we have are the ones where both parties are saying, yeah, I want this to be construed my way, not voidable, not making the contract voidable. They want to say, we had a different interpretation. Could have gone this way, could have gone that way. We want this to go this way. We want this to go our way, rather than voiding the contract. That's usually what they're fighting for. And even the party who's, quote, adversely affected, who wants out of a voidable contract, it's still the same thing. They still want the contract read their way, which lets them get out of the deal, right? It's when the remedy of getting rid of the contract aligns with their argument about the value of the language that they're able to do that. Hey, yeah?
This is the boat case where they're like talking past each other and
Yeah, that was excellent. I mean, brilliant. That was my next question. Here was my next question. Hey, let's say I took section 151, 2, 3, and 4 off the table. How would you make the argument there was never a contract? Yeah, this is a boat case. Make the argument. Let's introduce the boat argument, Raffles versus Wickelhaus. Let's introduce that to this case. Go for it, Jewel. Yeah, and this is going to be rough to talk about it with a straight face, but how were they talking about different boats? Because it's the same property. What?
Because they're leaving at different times. They have the same name, but they're.
Well, that was what Peerless was doing, but here we have only one property, so we got to figure out what's going on here.
People thought they were buying a property that had a functional sewage system.
Right. They thought, remember what they said? We thought we were buying an investment property, right? You sold us a non-investment property. Can you see the meeting of the minds argument there? We're talking about different properties. By the way, did you notice the Rosewood case in the back of the thing? This is the infamous case that just demonstrates why this is bullshit on stilts, but we need to make the argument to see it, right? We need to make the argument to see it, which is, let's go back to Rosewood, the Barren Cows case, right? So there they tried to use Raffles versus Wickelhaus, the boat case, to rescind a contract for the sale of a cow. The seller wanted the cow back. They wanted to rescind the sales contract and get the cow back. Why? The seller argued, because I thought I was selling you a barren cow, and you thought you were buying a barren cow, and it turns out that the cow wasn't barren, so we were talking about theoretically different cows. What is wrong with Rosewood as an argument, and why don't we use Raffles versus Wickelhaus to resolve these questions? And we can, it's a tool, but like,
That gets rid of the bargain for exchange.
yeah, that's the whole point, right? Like, you get a better price for the cow, not because the cow is barren or is not barren, but because you're discounting the price.
The evidence is that it's not.
Yeah, because the evidence is that the cow's barren, right? Like, and so you're just discounting the price. Based on that, the price represents the risk allocation. I can't tell you enough. If you take one tool out of this area, it's this. Get it really in your soul that prices usually represent express risk allocations. Why would you disturb the price? By the way, this is the same dumb case as we saw, remember, in some of the early equitable estoppel cases. Remember the case where the guy rents the apartment to see the king's speech, right? And we say there's frustration of purpose, that ancient doctrine. And we say the purpose was frustrated because the king didn't speak. No, the price of the room was discounted by the chance that the king wouldn't speak that day. So it's a really easy way to understand some of these older cases and why we sometimes really seem to quite selectively apply them. Yeah.
I'm assuming in this case and in the cow case, the contract did not explicitly say you're getting a barren cow or you're getting an income property, because that would change the contract.
But even if they did, it would. But the thing is, an income property still represents the party's expectation that it was an income-bearing property. Like, you can sell me stock on the expectation that it's going to go up in value, but that doesn't impact the sale of the stock. Yeah. Right? You still sold me the stock, and the price that you sold me the stock at is both of our bets. I'm betting that the stock is going up. You're betting that the stock is going down. Right? So that it doesn't disturb that risk allocation. All right. What I need you to see is one thing. First off, could you make this contract go away if I took mutual mistake off the table? Yeah. You could try to make it go away under not restatement 151, but restatement 20, Raffles versus Wickelhaus, meeting of the minds. If I took, that's back at our formation part, right? Here we're talking about a defense of mutual mistake. What I need you to understand, it's the same freaking analysis as restatement 20, formation, just the legal arguments are a little different, and I guess formation's a cruder tool. Let's say I took restatements 151, 2, 3, and 4 off the table. If I tell you the state of denial does not recognize restatement 20 because it's stupid, and it doesn't recognize restatement 151 through 154, can you still address this problem of the investment property? That's another way of doing it. You're representing the buyer who's trying to get out of this, because they're the ones that lost under our caveat emptor. Implied kind of. Remember our restatement 200 and 201 and 220, where we're interpreting the terms? Hey, by the way, is there a case that we might pick out of the hat, in which the parties argued, we just disagreed about the fundamental subject matter of the agreement, and the court's like, nah. It's that one of you knew perfectly well something that the other one didn't know. Arden v. Horan begins to bear down on it. Bailey, you had your hand up?
The case where they said that it was like a certain millimeter, and then it wasn't actually, and then the guy knew, and he should have known.
And he should have known, and he did that, and that's Colfax, and that was your question earlier, right, when we decided how does Colfax work? And I remember at the time I said, this case is meant to introduce you to Raffles versus Wickelhaus, but that is not how the court carried it out, because the court didn't want to undo the union agreement. It wanted to pick a path for the union agreement to enforce it. And so it did that through, and if you take a look at it, right, let's just do that now. If you flip to restatement 201 and 220, whose meaning prevails? You will be shocked as I read the holding of Colfax off chapter and verse. Where the parties attach the same meaning to a promise, it is interpreted in accordance with that meaning. Where the parties have attached different meanings to a promise, it is interpreted in accordance to the meaning attached by one of them. If at the time of the agreement, that party did not know of a different meaning, and the other party did have reason to know of the first party's meaning. Want to do it again? 221. Right? Where we're going to say, well, actually it's 220. Sorry, it's 201 and 220. 220, an agreement is interpreted in accordance with a relevant usage if each party knew or had reason to know of the usage and neither party knew or had reason to know that the meaning attached by the other was inconsistent. 2, when the meaning attached by one party, this is Colfax, accorded with a relevant usage and the other knew or had reason to know of the meaning attached by the first party, then we give the term the meaning attached by the first party. Look, why do I raise this? I raise this because I have a tendency to write very long issue spotters sometimes. And when I do, right, like the ad, I don't always write issue spotters around misrepresentation, mistake, and meeting of the minds. But when I do, I am quite likely to give you a fact pattern which is going to fit into all three scenarios, and I just need you to see it. I just need you to see Colfax round 1, Raffles versus Wickelhaus. The contract was never formed because there was no meeting of the minds. And I need you to see how that's both very powerful, but also a bit of a blunt weapon, because all you get with that is undoing the contract. Would have worked here. Would have worked here, which is why they tried it, right? That buyer wants to undo the deal. They want this terrible property back on the seller. It doesn't matter to them if they undo the contract. Good. That's what they're after, rescinding the contract, right? So they tried it. Court's not going for it, though, because Rosewood Kennels and because Raffles versus Wickelhaus are pretty much nonsense cases, because the risk is allocated through the price term, and modern contract law definitely chooses to enforce contracts according to an interpreted meaning rather than undoing the whole package. But notice that would have been an argument, and then also there would have been an interpretation argument, and then also there is this mutual and unilateral mistake argument. And all I want you to do is take a fact pattern that is going to be kind of a mess and be like, yeah, but I can do this any of these three ways. And then add misrepresentation 164 on top of it. And so for the full answer, you're like misrepresentation, mistake, meeting of the minds, mutual mistake, unilateral mistake. And there is, in fact, an issue spotter out there that does exactly that. It's just going to climb through misrepresentation, mistake, meeting of the minds. Just go see if you can find it. That's all it's doing. All right, cool. So I need you to see it's the same fact pattern. Any other questions on this one? It's otherwise pretty straightforward. I guess one final point that I just want to make is a practical practice matter. Who's the jerk in this case? The seller?
Or the person who initially put the septic tank in.
There we go. Right? Your basic problem is that the seller and the buyer are both innocent. And the court's trying to allocate a risk between two parties, neither of whom knew or had any reason to know of the problem, right? And this is a fairly standard problem. A lot of times you're going to see the jerk in the case and you can be like, I need my wind. I want my wings, right? But I can't get to it. And that is because often the person, and you can write this down if you want, although it's straight up Fairfieldism, it's just a pattern through the cases. because the person you truly want to sue in many contracts case is dead, broke, or gone. Dead, broke, or gone. And in cases where, why isn't this person being dragged into this particular lawsuit? Yeah, because of privity of contract. Remember, we just had this big dark night of the soul about privity of contract? This is what it does. By the way, keep this case in the back of your mind, just a little asterisk. Color code it so you don't pay attention to it until after you're done with the class. Because when you get into property class, you're going to reread this and be like, boy, did they have some options. Because contract law works very different from property law. Contract law runs between the parties who sign it. Property law changes the rights of anybody who comes into possession of the property. Which means you can drop the hammer on people for crap like this using property law, not contract law, but not contract law because there was no privity of contract. Okay? Further questions on that before we move on? Yeah, Joel.
So do you think if they hadn't included an as-is clause that the court might have found differently, or if they abused the price?
This last point that the person you really want to go after is dead, broke, or gone seems to me to be real dispositive. Like, I bought it, you sold it. I guess if there was no as-is clause, the court would try to look for standards. Like, did you sell me something that wasn't okay? And maybe, as will turn out, maybe the answer is yeah. Remember that implied warranty of merchantability that we get for goods? It turns out there's a weird mutant cousin. Usually only used, and other, because if I don't say this, you're going to get super confused and apply it to everything. Everyone will. It generally, as a practical matter, only applies to new build houses. But sometimes there's an implied warranty for houses, an implied warranty of workmanship, or an implied warranty of workmanlike conduct for new build houses. And then there's also an implied warranty of habitability, which is like the like anti-slumlord kind of deals. That'll show up in your property class. And so if it violates those implied warranty of habitability or implied warranty of workmanlike conduct implied warranties, and you didn't disclaim those implied warranties, then yeah, that would change the outcome of the case. But you need those background industry custom and practice warranties like warranty of habitability, warranty of workmanlike conduct, warranty of workmanship for a new build house. You would need something like that to give that implied warranty so that when you breached it, they would say, yeah, you breached a contract term that didn't appear in the contract, but got added to the contract because it's an implied term. Therefore, you breached it and you didn't disclaim it using as is and with all faults, and therefore the term is there and the term is breached and you are liable. Yeah, you bet. Yeah, Scott.
Just confirming, the courts don't really consider whether it's a reasonable price at all in a lot of these cases.
Nope, and why not?
Because they're just not in the business of saying what's reasonable.
Yep, and why not? They'll say anything else is reasonable, but they won't. If I buy a fragment of cardboard for $10,000, they're not getting involved. They don't like looking to the sufficiency of consideration. That is a very technical and good black letter statement of the law. And from the perspective of economic analysis of law, why don't courts like looking into the sufficiency of consideration, Nick? Because it is profoundly subjective. And if you need the language from economics, this is the problem of, anybody got it? Kind of Pareto efficiency, although remember, Pareto efficiency avoids this problem by saying everyone has to be at least as good off and at least one person has to be better off. So they just avoid the problem of subjectivity by saying, we'll just only focus on cases where everybody's better off. Right? Which doesn't entirely solve the subjectivity problem, but it does a little bit. I mentioned it a couple times. This is the problem. The subjectivity is?
What you were asking is the answer of consumer surplus?
Well, consumer surplus is based on that difference. The difference is created, though, by something called interpersonal comparison of utility. Interpersonal comparison of utility. You don't know, look, to be clear, your value of this gold ring on my fourth finger is profoundly different from my value of this gold ring on my fourth finger. And there is no way a court can engage in like mind reading to figure out what that difference in value is. The only way we recognize that consumer surplus, as David points out, is to get cash on the barrelhead offers. Where you offer me, like the only way to find out what it's worth to me is if one of you offers more than it's worth to me and I take the deal. There's no other way of measuring it, right? That's the problem of interpersonal comparison of utility. So because of the problem of interpersonal comparison of utility, courts do not inquire into the sufficiency of consideration, and they generally, although we will come back to this when we find unconscionable deals, where somebody's gotten a terrible price and they're a little old lady and they had a salesperson who kicked the door in and wouldn't leave and like forced them to buy stuff. We do get those cases. But you need a lot more in your surrounding context than simply a crappy price. Because people get to make crappy decisions at crappy prices all day long. That's just how we get consumer surplus. Okay, cool. Let's move on. Monarch, restatement 153. Gracie, would you mind setting that up for me, please?
Monarch was a label-making company.
Yep.
And they were selling labels to Reeds.
Yep.
And Reeds wrote for M on the label form. He says that meant 8,000, but he probably just meant right core M. But the label making company read that as
MM can mean something else, and
million. So they ended up printing 4 million labels and delivering them, and Reeds was like, hey, what the heck?
First of all, can you imagine being in the building? Like, that is a career-limiting move, right? You're just like, wait, where? This is like the Sorcerer's Apprentice, but with labels. Okay, what's the court say?
Court says that this was Reed's mistake. The MM was the, as million was the accepted custom and practice of the industry. And it was Reed's mistake. Additionally, Monarch cannot be put back into the position they were before they made the mistake.
Perfect. We've got both elements of it. Let's bear down on this. So this is restatement 153. What's Reed trying to get done?
Reed doesn't want to pay this much.
Yeah, Reed doesn't want to pay this much, so what are they looking for? What's their remedy that they're asking for? I know we're skipping ahead to the last part of the class, but what?
They want it to be canceled.
Yeah, they want the contract to be voided or modified. Either would be fine by them. They want the contract to be voided or modified. Notice that they would be good with either outcome, right? What's the restatement 201, 220 approach to this case? And this is a totally unfair, very hard question. I'm well aware of it. Because we're going to do this under 153, but I need to show you how you would do it under 201 and 220.
It's the different meanings.
Yeah.
Prevails.
Yeah, whose meaning prevails?
The party who, like if there's a party that knew there should have been a different meaning and they don't say anything.
Yeah, and who in this case damn well knew that this is one of these what's called scrivener's error cases. That's what this case is. This is scrivener's error. Do you want to know what the most common cause of scrivener's error is globally? Typos? Coffee in the morning? No, it's two little things that will haunt your freaking nightmares. Commas and decimals. Why? Why do commas and decimals? Oh yeah, because?
Yeah, because in Europe, a comma, it doesn't mean anything in a number. It's a decimal. Yeah.
All right. Can you see this one? So these decimals then hit it, right? And they become millions instead of thousands. Or 4.00.000, that is 4 million, not 4, right? Same thing with us. When we use commas, they get profoundly messed up. All right, so that's scrivener's error, and scrivener's error cases often do get fixed where one party's made a mistake. Now, what I need you to know is, make the case. They knew. They should have. They knew that there was something to be.
They should have known
because
the request specifically asked for them to mail it in a certain way.
Yeah.
And it was completely unreasonable to mail that many in that way.
Right. So one just the rest of the context of the contract made it clear. Want to expand that out? There's a couple other reasons why.
Yeah, they might have been able to just see the size of Reed's photo mart and just know that they couldn't possibly need 4 million.
That's just right. Like just the whole context is wrong. Austin, yeah.
There were, I think, 5 total orders,
Yeah.
and this was the only one that was that long.
Like we're ordering, 2,000, 1,000, 700, 8 million, right? Like at some point you knew, or at least you could have asked. You could have Colfaxed it, right? You could have asked. You clearly knew at this point you were on notice that something went wrong. Well, I just want to point out that's how you would resolve this case using 201 and 220. One party knew or had reason to know that the meaning that the other party attached was off. And that matters. This is a 220 case because what do they say about, Gracie, what do they say about this MM and why do they hold that as millions rather than thousands?
They hold it as millions because that's the custom of the industry.
Because that's the custom and practice. That should make sense by this point in the course. MM does in fact mean that, like that's true. At the same time though,
Also, Reed argued that it meant 2,000 in like Roman numerals. Like that's a really bad argument.
oh no, it's not. Whoa, I think we need to step back a moment. Why does MM mean million in the industry?
So 1,000.
1,000,000. It's all thousands. It's all Roman numerals, no matter whose interpretation we're using. It's all Roman numerals. It's just, are Roman numerals 2 in a row? Is this 1,000 plus another 1,000? Or is this 1,000 times another 1,000 in the standard industry custom and practice? It's all 1,000, right? The question is it 1,000 plus 1,000 or 1,000 times 1,000? Yeah.
Yeah, to be fair, if interpreting it as 8,000, you definitely just do 8M.
Yeah.
Because why would you do
M.
2,000?
Yeah, no, right. That doesn't make for 2,000, right? Like that doesn't make any sense either. That's clearly wrong, right? But the MM at least could be industry custom and practice. But do we have a response? Do we have a response to that? It is industry custom and practice. It is industry custom and practice that MM means a million. Can anybody read 220 and give me a response to that?
Industry custom and practice not to order 4 million.
It might be an industry custom and practice not to order far more than you need. And also, what does 220 say about custom and practice? If we were to not be doing this as a defense, question 4, but if we were to be doing this as a matter of interpretation of the terms, what does MM mean? Question 3. Yeah, go for it. It should only be used when you can't do those things. And also, remember, 222. When a meaning attached by one party accorded with a relevant usage, and the other knew or had reason to know of the usage, the other is treated as having known or had reason to know the meaning attached by that party. So at least there's an argument. It's not a great one, but there's an argument saying you were using some notation, and it was pretty clear how you were using it, and we at least knew that we had a different interpretation than you did on that. And so there's at least a Colfax argument saying, we're going to use your interpretation. Now to do that, though, you would, in all fairness, you would have to show that MM meant 1,000 somewhere in the industry custom and practice, because you need that usage to be sticking to. All right, cool. That's all there is to it. This is just a case of unilateral mistake. We have one last point. This does, under 153, if you get 153 under your nose, this does seem like they're going to have a chance at getting out of this. Where a mistake of one party, not both parties, that's what makes this unilateral mistake. When a mistake of one party was made as to a basic assumption on which he made the contract and it has a material effect on the exchange of performances, that contract is voidable by him if he does not bear the risk under the rule stated in 154, that's Nick's rule. And then, Gracie, why is it that in this case the court's like, yeah, one party did make a mistake, and there's even a very real chance that the other party should have been aware of that, but we're still not letting them out of this under Scrivener's error? And you already gave me the answer to that, and I'm just trying to square that with the stuff in the stuff in 153. Yeah, go for it.
If the stamps are, if the labels are a movable good.
Yep.
And but we're using restatement here.
Yep.
Why?
It's a great question. We could say it's a service under the predominant purpose. By the way, how does this work out if we use this as a good? It's a really great exercise. And it's the reason why I just did this. How are you going to deal with this if it's a goods case? I love it. Yeah.
Could you argue the UCC to 207, where it's like
So the offer and the acceptance differed. Oh, there becomes now profound problems. Do you even have a, this becomes a hard question. Do you even have a 2201 statute of frauds writing? You do, the purchase order. What do you need for a statute of frauds writing?
Quantity, signature, item.
Right? Quantity, signature, item. That works for both statute of frauds. Why, though, do those particular exchange of forms not work under 2207? This raises one very nasty advanced question. What's the different term?
Is it because they're like custom ordered labels? They can be, it's like a VW glass, custom glass sort of.
I mean, maybe, but that would get us past the statute of frauds.
Is it because the guy from Monarch had to send in a separate order to the plant in California?
Yeah, so we now have two forms, right? And those forms are different. What term is different? What term is different? The quantity term. Well, what happens if you knock out the quantity term using the knockout rule? Then you don't have your statute of frauds writing. You see that? We're left. That's why when I tell you to not cross the streams, there's actually one advanced question. There's only one time that the Ghostbusters let you cross the streams. Question 1, is there a contract? Question 2, is it enforceable? Question 3, what are its terms? The only time you go back to question 2, enforceability, and import a term is on the quantity term under the UCC. And here we have exactly a case where the quantity terms arguably differ. What are we going to do with the industry custom and practice stuff, though, on the meaning of MM? What are we going to do if this is a code UCC contract and not a services contract to print the labels? What are we going to do about MM under the code? Sorry, was that a dangerous pen, or are you thinking?
Did you move the community context?
Yeah, why? And you're moving the community in context to do what under the UCC? What are you after with MM? What does MM mean? Industry custom and practice. You're going to shrink or expand your industry to get the industry custom and practice you want. And that's how you're going to do it. You're going to say 1303. The evidence is admissible to give meaning to the terms of the contract. And it did. It gave meaning to the fact that MM means a frickin' million. That's what MM means. And we're going to find that under the UCC, and that's why this is such a great question, Gracie, thank you. We're going to find that under the UCC as a function of 1303, course of performance, course of dealing. Oh, by the way, could you raise evidence of course of performance and course of... So trade practice, trade industry says, 1303, you with me? Trade practice says MM means a million. Can anybody use 1303 to win it for the other side? What's our hierarchy in 1303? What beats what?
Like course of dealing or?
Yeah, course of performance beats course of dealing. Course of dealing beats trade usage. In this case, how are you going to beat their trade usage claim?
Like we've never done 8 million.
Look at the freaking course of dealing, you morons. It's clear we were ordering thousands, not millions. You see that? Course of dealing trumps industry custom and practice. So like, it's not an end game here. It's just your like Gracie's question's a really great one. What if we dealt with this under the UCC? And the answer is we would go to 1303 and prove the meaning of the terms using course of performance, course of dealing, and trade usage, and our arguments would be related to those kinds of back and forth. All right, cool. Yeah.
So what my question was,
Yep.
I think I know what the answer is, but just to double check. So it does specifically say that in label making trade, MM means 1 million.
Yeah.
But that's not
not to say that Reed's Photo Mart is an expert in label making. You could argue that they just used a piece of jargon without necessarily knowing what it meant or even knowing that was a piece of jargon.
Yeah, except what's a court going to say about using jargon that you don't know what it means? Lucy versus freaking Zamer.
Suck it.
That's the legal term. Yeah, like that's a you problem, right? Like, seriously, y'all, this is why you don't let your excuse me. This is why you don't let your clients write their own contracts, right? Because they're going to start using persons instead of people and other weird legalisms, and you're just like, no, new rule. You're not a lawyer. You're not allowed to use our guild language. Shh. Stop chat GPTing crap. It's like, I swear to God, we finally got hit with the equivalent of Dr. Google that has haunted every doctor. And now ChatGPT is haunting our intake interviews. They're like, I know the law. You're like, no, you really don't.
So I understand why the court ruled the way that they did because you can't send online to the position they
Yep, yep.
But I'm confused why the court didn't say anything about the representative because they mentioned that he was there only for like a month and that he also came from the service. Why didn't they say anything about that?
Yeah, I think because they realized it was one party's mistake. That party bears the risk unless you can undo everything. They just weren't interested in trying to unpack the other stuff. I would have made more out of it. I think it's a great argument. I would have made more out of it, but I don't think the court was real eager to say, hey, this is water under the bridge now, like this has been delivered, and we can't put you back in the position that you would have been in had the contract not been voided. I will point out one thing. The remedy here is not our standard contractual remedy. Remember, our standard contractual remedy, when we get to remedies, will be to put the non-breaching party in the position that she would have been in had the other party not breached. This is not that. This is rescission of the contract, voiding of the contract. This is putting the parties in the position they would have been in if the contract had never been made. Now, we've seen that a couple places before in detrimental reliance. That would be a great place to talk about that. But just, it's a really great divider when you're trying to figure out what a court's doing and what law to rely on. Ask yourself what world it's trying to put the parties back to. Is it trying to put them back to the contract was never made? Or is it trying to put them back to the contract was made but was not in fact breached? And those are two big paths that we can go down. Okay, any further questions on this one before we move on? All right. Duress, and we're then going to begin to get into public policy and illegality. Aiden, if you wouldn't mind setting up Klaus versus Myers, please.
So Patricia Myers was operating the Green Door Tavern. She had a 3-year lease from John Hearn for $500 a month. She entered into a contract with a patron, Klaus, and the contract was titled employment/management contract. In the contract, Myers referred to herself as employers and Klaus as employee. It recited that Myers operated the Green Door from Hearn. She agreed to hire Klaus to manage the business for 4 years, and Klaus would get 60% of the profits. Klaus was going to pay $15,000 over 2 separate payments. And then at the end of the contract, Klaus was going to get a 60% ownership of the business. Once the contract was executed, he started actually running the bar. He was notified from liquor control that he needed to bring his contract and Myers to their office with the liquor license. The liquor license was still under Patricia Myers' name and did not have Klaus. He ended up losing the liquor license, and then he later got one in his own name. After he got the liquor license in his own name, he asked for his $7,500 back from the Myers. The Myers refused, and he filed suit alleging he was induced to enter the employment contract based on a false representation that the Myers were a partner in the business. And the Myers also filed a claim trying to get the second payment of $7,500.
And what's the court do?
The court says that they were both violating the law when they entered the agreement. So the purchase is void. He doesn't have to return $7,500, and he doesn't have to pay the extra second.
Right, the court's just like, screw you, I'm not getting involved. right? Period. Okay. What's this case doing in the book?
I feel like it's just kind of showing us the lack of a law that if you break the law when you enter a contract, you won't get relief from the result.
We do not enforce illegal contracts. This is under our defense. This is our defenses question, right? Formation, formalization, terms, defenses. This is a defenses question. What's the defense at issue in this case, Hayden? Oh, to open it up to co-counsel, what's your defense? Yeah? Illegality. That is, this is, and notice we say illegality because we don't want to say what it really is. What really is your defense here? It's not just illegality. Go read the headline to this section. What's it start with? Public policy and illegality. Why do you want to say illegality and not public policy? Yeah.
Public policy is a little bit more likely to be overturned than illegality.
Yeah, like public policy is insanely weak. That's how you lose. Now, it's not how you lose in your statement of facts. It's not how you lose when you frame the case up front, but it is how you lose if you say, hey, I know we had a contract, but I think it's just super important that the parties not actually abide by the contract because of how I feel about life. Also, see Bambi. Bambi thinks that you shouldn't enforce this contract either. And it's not like, it's just not persuasive as a legal claim. It's super persuasive if you've got Bambi like all over your statement of facts. The court's like, oh, Bambi. Let me see if there's actually a black letter law way to help Bambi. But if we just use this as our black letter law, we're going to get murdered. And that's what this whole area is about. Public policy, I get it. These are public policy defenses. But we immediately move to like illegality because that one at least you begin to say, I get it. Okay, cool. Why do we enforce contracts? Why do we enforce contracts?
Bargain for exchange
Bargain.
makes everyone better.
Yeah, bargain for exchange makes everyone better. Why don't we enforce illegal contracts?
Because on that, people are worse when there's illegal protection.
Right, and why is that in the language of economics? If anybody happens to want to take a crack at it. Well, kinda. It can be one form of Caldor-Hicks efficiency, although if it was Caldor-Hicks, we would say things like, oh, the illegal contract made one person better off and made somebody else worse off, and so we would still enforce it, and that's a rough one to hoe. Now, there's a deeper problem under economic efficiency, which is economic efficiency only works when our deal makes both of us better off. But notice the Pareto efficiency goes beyond that. It doesn't just say both of the parties to the contract better off. It says no one is worse off. No one. This is called a silo externality. An externality is a person or an entity who is out, it's an effect that a private deal has on third parties or other people. A core externality would be something like, I run my factory and I sell you chainsaws, right? And that's great. The value of the chainsaw is worth more to you than it is to me, and the value of the chainsaw is worth less to me than it is to you, so when you give me money for chainsaws, everyone's happier. Is everyone happier? No, not the person with stage 4 lung cancer living next to my factory who's been breathing that crap in the whole time. That's an externality. See how that works? Illegal contracts are just a key, easy example of externalities. They violate our basic principle of contracts are the law of bargain for exchange because they dump the costs on a third party who did not have the ability to negotiate, to bargain. And that's why if I enter with a contract to you to commit murder, it's void. Like no court will ever enforce it because the costs of that deal is being dumped on a third party and not on us. All right, that's illegality. Otherwise, like pretty straightforward. You're not going to get contracts enforced that are illegal. Any questions on that one? Yeah, go for it. Pleasure.
What if it's illegal because it's like a victim's crime?
Yeah, and there are all kinds of problems of like, is something illegal? This is one of the problems that we're finding out sort of in our present climate right now, if you read the book 3 Felonies a Day, in the framework of over-criminalization. By the way, you have all committed 3 felonies by this point in your day. That's just what overcriminalization does. There's just a statute somewhere with your name on it. Most of them involve intellectual property stuff. Like if you've used a computer today, you fell on you. Like it's just all going to be there. So like under some circumstances, given those frameworks, it can be really hard to say like, what about things that are illegal? Like, but you're arguing whether it really applies or whether it falls into that category or how big a deal it is. That does come up. There's a reason why I said no court will ever enforce a contract to commit murder. Whereas, like other things could theoretically be illegal if you pressed them under some interpretation of the statutes. And I think courts would treat those quite differently. Like for example, most contracts to use AI, which are probably monopolization software because they take a wide range of prices and compress it down to a single range of prices. And so people who use them are probably violating antitrust law. But that's not decided. And so I would never say that like a software license agreement to use AI is per se void for illegality, just because you could make that argument that one inevitable application of AI does lead to something that we would call illegal. It needs to be pretty cleanly illegal. Okay, any questions on that one? All right, and we're gonna keep cruising. That one's fairly straightforward. At which point we are going to get to Hopper, and yeah, we're going to have to go over next time. So I apologize, Ben, but we'll pick it up. We'll pick it up next time. Go ahead and let's open Hopper and talk about it.
So Dr. Glenna Hopper was a part-time veterinarian with All-Pet, and she was practicing under the guidance of Dr. Johnson. He offered Hopper a full-time position. It was an oral agreement. It was conditioned on the acceptance of a non-compete agreement. The non-compete was after 30 days notice of leaving, she would not be allowed to work in a small animal clinic within the geographic area of Laramie, Wyoming, for a period of 3 years. And she agreed that it was reasonable. She worked there for a year. 1 year later, Dr. Johnson had heard that Dr. Hopper was looking to purchase a small animal veterinary practice in there. In response, he sent a letter basically saying, I don't have a non-compete agreement for large animal medicine. You're looking to purchase a small animal clinic. I'm willing to release you for a cash buyout. In response, she essentially told him,
Pound salt.
See ya. So he informed her that she was essentially toast from All-Pet, and she subsequently purchased the small animal clinic. I think the big problem here was, I believe the client list was 368 initially, and it grew to 950, and of those, 180 something were All-Pet clients.
They came over.
Which Dr. Johnson obviously was not pleased with, and
Yeah.
represented her breaching the non-compete because she had special knowledge of All-Pet's client list.
Yeah, perfect. What's the court do with it?
They determined that it was not enforceable because it had to be, she was within her rights.
How so? What's the restrictions of the court? Well, let's just back it up, and we'll continue this next time. But let's back up a second. Why would All-Pets be, I think, excused? Like, why did their attorney say, yeah, you need to have your attorneys, your clients, can't even speak, your vets sign non-competes?
Because they have a special interest in their client information.
Yeah, because you want to keep your clients, and you're not hiring people to let them steal your clients. Like, that makes perfect sense. So it's an enforceable deal. Let's go through the first 3 questions of our class. Is there a contract? Yeah, absolutely. Is it enforceable? You're damn right it is. And are we relatively clear on its terms? Yeah, absolutely. What's the defense? And we know why they did it, like an economic perspective. It makes sense. They want to protect their client list. Why they? So what's the defense here?
The damages were speculative, I believe.
We need something deeper, though, and this is where we're going to pick it up next time. Why is the court suddenly having a crisis about enforcing a mutually agreed upon and clear contract, which we do not generally see? Under this weirdness of public policy, the weakest of the arguments. What's going on, Lucas?
This type of agreement has to be reasonable, has to not be bad for the public, and it also has to be have a legitimate duration. And they basically said that the duration on the agreement was too long for it to be a reasonable agreement.
Okay. Do courts generally, and we're at time, but let me just ask you, do courts generally just rewrite contracts? Take 3 years, make it 1 year? All right, that's where I'm going to start next time. What the hell is going on? Why is the court suddenly doing something they will never do, which is they've taken out their pen and they are rewriting the agreement? Thank you.